for all of you in waiting. We had to make sure we had a quorum before we started the meeting, and we've got members on different committees throughout the building. This is not our usual time that we meet, so it is a little difficult to maintain quorum, but we're going to do our best. We're going to consider 3 bills today: House Bill 39, House Bill 95, and House Bill 96. Pierre, will you please do a roll call?
Senator Kriegel.
Here.
Senator Crum.
Excused.
Senator Hicks.
Excused.
Senator Cole.
Present.
Chairman Olson.
Here.
You have a quorum.
All right, the first bill for our consideration is House Bill 39, Firearms Rights Restoration Amendments. Representative Washit, welcome.
Good afternoon, Mr. Chairman, committee. Glad to be here. Today we have House Bill 39. We've been working on restoration of gun rights for several years. We've made a few tweaks along the road. Last year, we passed an amendment that everyone, I think, in this body thought meant one thing. And then we learned later that the legal office of the state government came up with a different interpretation. And that had an adverse impact on one of my constituents who's with us today, and he'll testify in a moment. He brought this to my attention. Then worked jointly with our LSO staff and the attorneys from the state legal office to find out exactly what was the issue in last year's wording. This bill was narrowly drafted to fix that specific language flaw that was detected by the state legal office. Nothing else has changed other than on the House side, we did add an amendment at the request of the Secretary of State to deal with clarifying that this bill was specific to firearms rights and not any other restoration. And so with that, the language change is found on page 2 and 3, where we say, or the laws of the jurisdiction in which the conviction was entered, which was the issue that you're going to hear about in my constituent's testimony, where he was convicted many years ago in another state. That state subsequently restored his rights. He moved to Wyoming, believing he was golden with regards to his firearms rights, only to discover last July that things had changed, a different interpretation had been made, and he was now considered a prohibited person again. So with that, I'm happy to stand for questions or have my constituent, Mr. Stovall, tell you his story.
Questions for Representative Washit? All right, yeah, let's hear from your witness.
There you go.
Hello, Mr. Chairman. Thank you to yourself and the committee for taking a minute to listen to my story. My name is Corey Stovall. I'm a resident of Casper, Wyoming. As a previously licensed hunting guide by the Wyoming Board of Outfitters, I'm here today in support of House Bill 39. Due to the law that went into effect in July of 2025, I was unable to guide clients for the fall hunting season in 2025. The current interpretation of the law removes my previously restored gun rights, as you heard. With the current interpretation, I lost valued income to support my family. I lost valued time in the field teaching my kids and my clients safety and ethical harvest of game animals. This House bill changes the necessary wording to allow not only myself, but others who may not be aware that the law has changed and legally possess a firearm after having their rights restored in the jurisdiction to which the crime was originally committed. I ask for your support on House Bill 39. Thank you.
Committee, any questions? Senator Cole, please.
Yeah, thank you, Mr. Chairman. Yes, could you elaborate on what happened? I mean, I don't know what, you didn't say what it was that you were convicted of, and then You know, how it proceeded. So that was my question.
Mr.
Yeah.
Stovall?
Sorry. In 2004, I was convicted of a nonviolent felony in the state of Washington. They have a 10-year wait period to which I waited and got my rights restored. What brought this to my attention was in June of last year, I went and purchased a suppressor for a firearm, which is a Class 2 tax stamp background check fingerprinted item.
It's class 3.
Oh, Class 3, sorry, I misspoke. It was to where I was granted the ability to possess that and inherited that suppressor. I went back later after July 1st to buy a lower to build and was denied. And during that denial, I appealed it, and that's what brought us to this point, that the new law that went into effect, the wording says it doesn't have an avenue to restore out-of-state firearm rights, which isn't what I'm trying to do. I'm just trying to honor what was previously restored.
Thank you for that clarification, Mr. Stovall. Any other questions? All right. Thank you, Mr. Stovall. Next.
Mr. Chair, members of the Senate Judiciary Committee, my name is Brian Gosch, lawyer with the National Rifle Association, here in support of House Bill 39. Piggyback on the previous comments to add that this area of the law involves state and federal case law, state and federal law, ATF rules, ATF interpretation of the statutes and rules, and a restoration process in federal law found at 18 U.S.C. section 1925C that hasn't been utilized since 1992. Prior to that, in a previous 10-year period, there were over 13,000 petitions to the Department of Justice, to the ATF, to look at restoration of rights. They put an appropriations rider in 1992 that defunded the ability of ATF to look at that. So DOJ had the responsibility as delegated under federal law. They delegated it to the ATF. Congress defunded the ability for them to review it since 1992. There have been no petitions reviewed or looked at since that time. With the new president, new head of ATF, they're renewing that process. The appropriations rider still exists, but they're with ATF, so they're removing it from the responsibility of the ATF, and DOJ is moving it over to the office called the Office of the Pardon Attorney. A final interim rule was written. We, as an organization, made comments on that rule to make it better. The Office of Pardon Attorney is hopefully going to begin receiving petitions and reviewing petitions this year. I hope that's the case because there's people out there who would like to do that. You have the law on the books in Wyoming. I think House Bill 39 makes that better because it acknowledges some of those restoration rights that were awarded out of state and recognizes them in the state of Wyoming. Once the petition are starting to be reviewed and we can see how that process is going, we can come back next year and take a look at the state law and see if there's a way to make it better in light of how things are going. But for now, understand that it's a complicated, I often call it a sticky process with the interchange of state and federal law. For example, one of our neighboring states implemented a law purporting to set up a restoration of rights process for those with simple assault domestic violence. As you know, since 96, no matter when that occurred, that particular offense, you became a prohibited person and remain a prohibited person. That attempt in South Dakota to restore those rights, absent a gubernatorial pardon, still exists today, but in reality, you still have to have that federal restoration of rights. And so, although you couldn't be prosecuted from a state basis, you could still be prosecuted from U.S. Attorney's Office. And so again, I call it a sticky process, a sticky business, this restoration of rights. We're trying to get it right. I'm happy to see the feds are going to start accepting those petitions, reviewing them, and restoring some rights for Americans. Mostly it's going to be for those nonviolent previous felons. And so with that, I guess I would stand down and stand by for questions.
Any questions for Mr. Gosch? All right, thank you. We're just wrestling. We're going through the language of this bill. There's not a lot, but I was Representative Washit. I was just trying to really understand the extra language on the new paragraph on page 3. This paragraph shall not be construed to restore rights to be an elector or a juror or to hold office of honor, trust, or profit. And maybe it's just there's not a better way to write this statute, but I understand how subparagraph A says you're incompetent to be all of those things unless, and then we plug in this new paragraph. So it may inadvertently make you eligible to be an elector or a juror. Maybe there's a better way to write this, but it just seems like it's just kind of thrown together. Where did this, who brought this amendment? Where did it come from? Help me understand a little bit more about it.
Mr. Chairman, the request for such an amendment came from our number 2 elected.
Okay, that's
It was
what,
drafted by legal staff within our service office.
right. Okay.
So those of us who are non-lawyers are kind of at their mercy sometimes when
Yeah.
it comes to these sorts of things and don't always pick up. If there is a more elegant way, I think it fulfills the purpose that was desired. The number 2 elected's office gave me a thumbs up when the language was drafted by our service office. But certainly if the committee has better language that would serve the same purpose, I would not be opposed.
Mhm. What, are you familiar, Representative Washit, with the statutes 713-105A or F?
Not off the top of my
Okay.
head, sir.
I guess, I don't know. I don't know if you have that statute there, Senator Craigo, but I guess I'm just curious why we don't just add another subsection after F for this language, the Romanet V. So it's not just a G paragraph under WS 713-105. Seems like that would have been the clean way to do it, and you wouldn't need this duplicative language, but I don't know that it matters a whole lot. Maybe I'm just being too picky, but I know it does accomplish what you want to accomplish. It's just a little clunky in my mind.
Mr. Chairman, I would add that it's our belief that this will cause no additional work for our department that issues these restorations, that this is simply an acknowledgement within statute so that proper notification can be made from our legal office to the agencies that run the background check stuff and get that clarified.
Great. Appreciate that clarification. Any questions, Senator Kolb?
Yeah, thank you, Mr. Chairman. Morning, Representative Washit. Nice to see you again.
Good to see you again, Senator.
So this, the question I have is, where it goes on to say, or the laws of the jurisdiction in which the conviction was entered. Are there any instances you're aware of that'd be problematic? And in so much as maybe we don't want to restore those rights because of the type of incident that happened. I mean, what are your thoughts on that?
Representative Washit.
Thank you, Mr. Chairman. Senator Cole, my thought is this, that the jurisdiction that took away somebody's gun rights has chosen to restore those gun rights. I think Wyoming ought to, in good faith and credit, acknowledge that. Same way if a chief executive from another state were to pardon somebody, we would certainly give full faith and credit to the pardon. So if they have a statutory process for restoring the firearms rights in their state, they're the jurisdiction that took away those rights. I think Wyoming should support that.
Senator Kolb.
Yeah, thank you, Mr. Chairman. Just to follow up on that, we've had other, issues come up with child predators and rights that were restored in other states, right? And then sometimes maybe we don't want to do that here, maybe because they don't ever, change. Maybe you could argue that. That's the reason why I asked the question, Representative Washit.
Thank you, Senator Kolb. Representative Washit, any response?
Well, I understand that, but at the same time, with lots of other things in law where one state recognizes or restores or gives back permits or licenses and so forth, we tend not to take those piecemeal, but rather, if a medical license is restored in another jurisdiction, we honor that.
All right, let's get some public comment. State agencies wishing to testify on this bill. Director Shannon. Welcome.
Thank you, Mr. Chairman. Mr. Chairman, Senators, I'm Dan Shannon with the Department of Corrections, and I'm here to answer any questions as you alluded to 713-105. Mr. Chairman, under 68, if the committee moves this forward, 68102 and 610-106 it really would have no impact on the issuance of or background checks from the Department of Corrections. As you mentioned earlier, we are governed by 713-105. So my understanding, it would offer reciprocity for those who relocated to our state if they received a pardon or had their rights restored, but Department of Corrections would not be involved in it. So I just wanted to bring that point clear, and also out of respect to the committee to answer any questions that you may have.
Great. Any questions for the Department of Corrections? Yes, Senator Craigo.
Thank you, Mr. Chairman. So and I probably should ask the good representative this question. So take example, Mr. Stovall. So he has his rights restored in a different state. He comes to Wyoming. This cleans up the firearms part of that. How do we clean up the voting part of that, the elector part? What statute does that fall under?
Director Shannon.
Mr. Chairman, Senator Craigo, in this specific incident that you spoke of, the individual did apply for his voting rights, and that does go through the Department of Corrections under 713, and we did issue his voting rights and such back. Firearm rights, as you're aware, it changed July 1st to say Wyoming only. So after July, when he applied, I denied it.
Follow up, Senator Craigo.
I'm just following up on your concern about the additional language at the end of the bill. Because of that, it seems unnecessary. It really does. And almost like we're creating another problem that we're going to have to fix, like we're fixing this one today. I don't know. It might be, I guess, a question for either one of you. Are we creating an additional problem where our number one lawyer, in the state is going to say, you guys now created another loop to jump through, and now there's no way to jump through it, actually. I'm just concerned. I have the same concern as the chairman next to me about that particular language.
Director Shannon or Representative Washington.
Mr. Chairman, Senator Craigo, that language certainly was not part of the original bill draft, and it was added only at the request of the number 2 elected. My personal judgment is I don't think it's necessary, because that process is outside of the language in this bill. There's other statutes that attend to that. Just trying to be cooperative, with our number 2's office, and that's why that language was added. If the committee believes that it's not needed, they're willing to have that discussion perhaps with the number 2's office. I personally have no objection to seeing that language removed from this bill.
Director Shannon.
Mr. Chairman, Senator Craigo, as 68102 and 106 are separate from 713. Under 713-105, the Department of Corrections is anyone that applies and meets the criteria as far as their civil rights will be reissued regardless of the firearms. So it is my understanding, I could be incorrect, if this bill moved forward, the Department of Corrections wouldn't be involved in this. This would be that we'd understand that we'd accept reciprocity from another state if a purchase of a firearm, things of that nature. But I certainly, to answer Senator Craigo's question, and in this incident here, we would issue their civil rights back to them as far as voting and juror and things of that nature.
Senator Craigo.
And not a question, Mr. Chairman. I just want to point out that, the cross section between all of these statutes has gotten so messy that I applaud you for just keeping track of it, Director, because it is a mess. We've created, and just the way you have to read all these statutes in concert is not fair to you or the people of Wyoming. And I think it's something we ought to look at cleaning up at some point. I don't know how to do it, but I know when you start reading through these and you have to have 3 of these in your hand at one time to actually figure out what people are entitled to do. And I think that's wrong. I think we need to clean it up for the average Wyomingite.
Subsection A of 6-8-102 has 5 ors in one paragraph. Even that's and that's not your bill, Representative Washington. It's just the way we keep adding onto into these statutes. We're not really taking time to clean it up. We just keep adding. So good job, Director, for
Well, to
being able to navigate these statutes.
Mr. Chairman, just one question, if that would change, when you mentioned earlier about adding to F, during the fiscal note opportunity, I submitted it would not have a fiscal impact on it because it was my understanding as I described. But if we had to review, we spend probably 3-4 hours on every application. If we had to, and we don't have one assigned person, it's broke up amongst a group of people. If we had to do that for every state that applied, I would ask for a reconsideration of that.
Okay,
Thank you.
fair enough.
Thank you, Mr. Chairman.
Any other questions, committee? Any other state agencies? Associations wishing to testify on this bill? We have no one online. Regular public comment? Welcome.
Thank you, Mr. Chairman and committee. My name is Mark Jones. I'm a national director with Gun Owners of America, live in Johnson County, Wyoming. I'll point out a couple things about this bill. We certainly support the concepts in the bill and the concepts of restoring firearms rights to nonviolent felons. When the 2023 law was first proposed, we did express two concerns with that law. We were concerned about potential implications in terms of what the federal government might think. And we were also concerned with the addition of gun control to the Wyoming statutes in 2023 that did not exist before. Under section 6-10-106, there was an insertion of the revocation of gun rights under Wyoming law that didn't exist before 2023. I think our concerns about the problems with the federal government were well-founded. As you probably all know, restoration of rights of certificates were ultimately issued to a lot of people with federal convictions. One of them was raided by ATF, and in February of 24, about 8 months after the law went into effect, ATF sent a message to the state of Wyoming saying, actually they sent it to federal firearms licensees saying the state of Wyoming is issuing restoration of right certificates for federal convictions that they do not have the authority to issue. So that law created a lot of problems that we kind of predicted. Can't go back in time, but I would urge, I firmly believe everybody in this room, including all of you gentlemen up there, want to do the right thing here. Let's make sure there's no unintended consequences this time, please. And the second concern I have is that addition of gun control in 2023. The addition of the gun control in 2023 was unnecessary, and I would ask you to consider striking that language in 6-10-106 that started revoking firearms rights under Wyoming law 3 years ago. That's not necessary for this process. So with that, certainly support the concepts. I would urge you gentlemen to consider the unintended consequences. I will say, related to the jury question, I did not consult with the Secretary of State. He came to that conclusion on his own, but my attorneys also said this might create problems with jury situations. So I would encourage you to look into the unintended consequences of that. And I'll stand for any questions.
Questions for Mr. Jones? All right, thank you.
Thank you.
Any other public testimony? No, I will go ahead and close public testimony. Committee, what is your pleasure?
Move the bill.
It's been moved by Senator Kolb and seconded by Senator Crago. Any amendments or discussion on this bill?
Mr. Chairman.
Yes.
I mean, I guess we can leave it for now. I'd like to dig into that last paragraph on page 3. Maybe, I mean, between now and when we get through third reading, figure out and make sure that is not going to cause some issues, and maybe everybody in the room can help us figure that out. We'll maybe run it by the #1 lawyer and see if that's going to create an additional issue that we don't need. So, but for now, I guess we can leave it. We can definitely handle it over the course of the next few days.
Yeah, I'm of the same opinion, Representative Washington. I'm confused by it and just want to make sure we get this right. So I'm not prepared to make an amendment right now, but I think we should work on this and make sure we've got it right. Senator Kolb.
Yeah, thank you, Mr. Chairman. I too share the same opinion. I think more is not good here. I mean, I think we're going down a road that we don't have to go down. We're stating things we don't have to state, and I look forward to the opinion of certain people who actually have a legal degree in this, but it looks confusing to me and unnecessary. I'll leave it at that.
All right, Pierre, will you do a roll call vote on House Bill 39?
This is a roll call vote on House Bill 39. Senator Kriegel,
Aye.
Senator Crum,
Excused.
Senator Hicks.
Aye.
Senator Cole,
Aye.
Chairman Olson.
Aye.
4 ayes, 1 excused.
All right, the next bill for our consideration is House Bill 95, Concealed Carry Colleges and Universities, brought to us by Representative Haroldson. Welcome to Senate Judiciary.
Thank you, Mr. Chairman and committee. Today, we're going to be talking about House Bill 95, concealed carry colleges and universities, and kind of give a little bit of a 30,000 foot high view of what's going on. So last year, as we passed an elimination of gun-free zones in the state of Wyoming, one of the conversations that came out of that I was not anticipating or expecting is I got a pretty high number of calls from college students in the state of Wyoming saying, hey, we're so excited about this, but the only way this works is if we get a Wyoming issue concealed carry permit. I've got a concealed carry permit from another state, and that doesn't work. It's not something that works. And so I dug back into the conversation and concept of the Federal Firearms Act, and if universities are covered under the Federal Firearms Act, and finding that they are not, I started having a conversation and moving forward with the idea of what would that look like to have a conversation of constitutional concealed carry at community colleges and the university. And so with that, I'll kind of walk through the bill and what we're doing here. So we are just creating a new paragraph in 68105B, which is our constitutional carry statutes, and that additional paragraph says any public college or university facility except for any public college or university athletic event where alcohol beverages are being sold. So it's just including the fact that a concealed carry permit or constitutional carry is available and acceptable at our university as well as our community colleges, again, giving that carve out of where the athletic events and where alcohol is being served would be carved out. So it's pretty simple in what's going on. It'll go into effect July 1st, 2026. And then that section 2, we see that repealing of 68105C, which is the portion that stated only with a concealed carry permit are we allowed to carry on campus. And so that is the conversation regarding House Bill 95 and kind of the nexus of where this conversation started, and would stand for questions.
Senator Hicks.
Mr. Chairman, Representative, the question I have here is the way this is constructed. It says for any public college or university athletic event where alcoholic beverages are being sold. So that's the entire universe. So let's assume that there was an event on the University of Wyoming campus. This looks like it's a prohibition against, at that time, across the entire campus. Is that correct?
Representative Haroldson.
Mr. Chairman and Senator Hicks, I'm going to back up just a little bit. If you go on page 2, lines 2, 3, and 4, this basically is just added into that subsection, this any public college university facility except for where basically the athletic event is. So I believe, as I've looked at this, and this is the same language we brought last year, is this just applies for the event where it's being held. So case in point, AA, Warmore. You couldn't carry at the AA. You couldn't carry at the War Memorial. Now you could be over you could be in whites or you could be in those situations. This also does not go in and affect the statutes we put into place or the guidelines we put into place on carrying or storage of a firearm on these facilities. But it would be in the case when an event where alcohol is being served, it would outlaw the area where that event is or where that alcohol is being served.
Thank you.
I think, and Senator Hicks, actually, I agree with your reading of this. I think the language is confusing. What it's trying to say, or maybe what it should say, is any public college or university facility, comma, except for in any facility at a public college or university athletic event where alcohol beverages are being sold. So that second part of the sentence intends to mean the event. It says athletic event, but it's not specifically saying that it's in a facility. It's saying across, I could see how it could be interpreted like Senator Hicks is asking across the college or university, but do I understand your intent is just to restrict it in that one facility?
Correct.
Okay.
And Mr. Chairman, I would definitely, I would definitely view that as a friendly amendment
Yes.
if you feel that's a clarity, and I wouldn't disagree with that.
Great. And then, okay, Representative Harrelson, so excuse my ignorance with all this, but under constitutional carry, just in general, that means that I can carry my firearm openly or only concealed?
So, Mr. Chairman, so this would just be, if you look up top, persons lawfully carrying concealed weapons in Wyoming under the statute. So this would be just concealed. There's two different aspects to this statute, the concealed aspect and then the constitutional carry aspect, which would be an open carry aspect. And so when we had all the conversations, both here at the Capitol, government buildings, and then also in their educational facilities, it was only ever to be concealed. We made sure that was only addressing concealed carry on both permitted as well as constitutional. And so this would just be in the permit or in the non-permitted constitutional concealed carry. So it would not open up an open carry conversation at our campuses or the university.
It's helpful. Thank you.
You're welcome.
Any other questions for Representative Harrelson? Yes, Senator Culp, go ahead.
Yeah, thank you, Mr. Chairman. Representative Harrelson. Has there been any issues since we've changed some of these laws in the years gone past with, the reasons why we had packed committee meetings? I mean, could you elaborate on anything that you know of that's happened since we've changed some of our laws when it relates to concealed carry?
Representative Harrelson.
Yes, Chairman Olson and Senator Kolb, crickets. Nothing. I've had a number of different students reach out to me thanking me. I've had conversations with facilities, our K through 12 facilities, and some of the laws that they brought in. I think probably one thing we did see come out of that was some pretty overbearing regulations being placed, or training regulations or training standards being placed on faculty and staff, but no incidents with a firearm that I'm aware of. Now, I may be wrong, but I have been actively searching and asking, and maybe someone behind me will tell otherwise, but from what I've seen, there's been nothing.
Any other questions for Representative Harrelson? All right. So the language, Representative Harrelson, that I'm contemplating here would read on line 7. It would say, except for any public college or university facility during an athletic event where alcohol beverages are being sold.
Yeah.
That's okay with you?
Absolutely. Thank you, Mr. Chairman.
Okay.
And Mr. Chairman, there's been a conversation floating around that I'd like to clear up too, if you guys
Yes.
don't mind.
Please go ahead.
I was informed this last week that I said I wouldn't be running any gun bills anymore, and that everyone was surprised to see these. And I had a meeting with some of our community college personnel, as well as University of Wyoming and our K through 12 about CTE, because it's something I'm passionate about. It's my background. It's a life that has been great for my family, and I want to see young people in the state of Wyoming have this opportunity. And in that meeting, I had made a statement that I was running out of gun bills and wanted to start moving my crosshairs in a different direction, no pun intended. And I didn't clarify to that group that I was running gun bills this year, but in the years going forward, that wasn't going to be the case. And so that's where that conversation, as you may have heard, that I had said I was no longer running gun bills. This year, I had 4 gun bills that I ran, but I'm finding that we in the state of Wyoming have phenomenal Second Amendment protections, and something that I am passionate about as well is CT. So just on record, will I ever run gun bills again? Maybe so. But my goal won't be to run gun bills in the future, as we've seen a lot of phenomenal things take place in this state. If there is a need, I will definitely work on making those needs be taken care of in the legislative realm. But I just wanted to bring some clarity to that, because I know that it was said that I had made the comment I would never run gun bills again, and what I had alluded to is the fact that was something that we were kind of walking through, and I wanted to start working on CTE going into next year if the Lord wills me in this position again. So just wanted to bring that clarification.
Thank you, Representative Haroldson. I really appreciate you clarifying that. I had heard the same thing that you had heard about what you had said, and I could not recall a year ago what you had said. So I appreciate you clarifying that.
And Mr. Chairman, that was actually just last month that conversation took place.
Oh, okay. Well, I wasn't there, so I wouldn't know then.
Yep.
Senator Kolb.
Yeah, thank you, Mr. Chairman. Representative Haroldson, if you stopped running gun bills, I would send an ambulance to your house. Just find out if you were okay. Thank you, Mr. Chairman.
Thank you, Representative. Any public, any agencies wishing to testify on this bill? No, okay, then I will take general public comment. Come on up. Start with Councilman Moody over here.
Thank you, Mr. Chairman. Through you, Mark Moody, Cheyenne City Council. On behalf of myself, I support this. I don't see any issues. I know from a city council perspective, when people carry, no issues there at City Hall. So thank you, Mr. Chairman.
That's helpful to know. Thank you. All right, and then whoever between the two of you wants to go, you're welcome to go.
Thank you, Mr. Chair, members of the Senate Judiciary Committee. Again, Brian Gosh, National Rifle Association, here in support of this bill today. One of the reasons that Representative Haroldson takes a look at new things is we have discussions after session ends, and we talk about bills in other states and what's happening. And one of the things we wanted to work on toward the end of session last year with this bill was something we decided to pass on and wait till this session or a subsequent session, because there were other parts of that gun-free zone bill that were very important. And we thought maybe just don't upset the apple cart for now and let it pass. But one of the things that did pass in a neighboring state at the same time was college campus carry, but it was also for 18 to 20-year-olds. And it also granted reciprocity for those from out of state who had reciprocity with South Dakota. That was something that was noticeably absent from this bill last year. So out-of-state attendees at the University of Wyoming or other colleges would not be able to carry. Of course, about the shooting incident on a college campus in 2007 at Virginia Tech. It started in a dorm and then went over to classrooms, and over 30 people were killed and injured. Just 2 weeks ago in South Carolina State University, a shooting started in what's considered a dorm-like complex. South Carolina State University, whole state of South Carolina, does not allow guns on campuses. And so how could that person have had a gun on college campus? The law didn't allow it. Of course, criminals don't care about the law, but those law-abiding citizens who want to defend themselves should have the right. And this bill before you, House Bill 95, takes that extra step to do that. 14 states do allow college campus carry. 3 allow 18 to 20-year-olds to carry. Utah allows open carry. This does not extend that to open carry. It does extend it to 18 to 20-year-olds with or without a permit. And we would support that, of course. I think there was one other comment I was going to make, and that was in relation to the facilities with alcohol. That language does not exist in South Dakota. They don't ban facilities that sell alcohol because, like Wyoming, South Dakota has a law that says you can't be intoxicated and possess a firearm. So regardless of where you're at, if you exceed that limit and you're possessing a firearm, you're illegal anywhere in Wyoming. So you wouldn't necessarily have to have it at all at a university facility that sells alcohol. In the South Dakota bill that passed last year, and again, there's been no problem in South Dakota since that college campus carry bill passed. They don't ban it based on where alcohol sales are. They just, their qualification was, look, if you're going to do something like they do at a Gophers game, where they have metal detectors set up and you're going to stop everyone from carrying and you have adequate security, then you can ban them. It's not based on alcohol sales. And with that, I'll stand by.
Any questions for Mr. Gosh? All right, thank you. Mr. Jones.
Thank you, Mr. Chairman and committee. My name is Mark Jones. I'm a national director with Gun Owners of America. And my colleague with the NRA has done a great job of explaining the rationale behind this. I fully support everything he said, especially regarding the alcohol situation. This is a common sense bill. We all know that shootings happen in gun-free zones, mass shootings especially. And we urge you to move this bill forward. And I know that it's Friday afternoon and we all want to go home early. We don't want to come back tonight. And since we have another bill, I'll stop my comments right there. Thank you.
Thank you, Mr. Jones. Thank you. Any other public testimony? Yes, please.
Thank you, Mr. Chairman. I am Brad Tyndall, president of Central Wyoming College, and representing the other college presidents and our 56 trustees in the Wyoming Association of Community College Trustees. And so my comments are going to be kind of complicated a little bit, if you could just bear with me a little bit in terms of how it relates to this bill. I feel like we are in a space at community colleges where we have some really sound, solid people for which we would say, boy, we would even do open carry, concealed carry, the whole ball of wax. And then we have on this kind of bell curve, those who, even though they're, 18, 19, 21, 22, you start going, we have some concerns. We have the whole gambit of people of mental and physical abilities. And so we're trying to navigate. And so, and I understand we have to have laws that draw the line somewhere. There's got to be an age where that's okay. There's got to be a permit that's that okay. So we're trying to navigate that. And our general stance is we like permits and we like age 21. And it's an idea when you're looking at that bell curve. And we have, each of our colleges have what we call a student of concern committee, because there are students who are, and the level of depression and psychological issues are growing up. People are speculating that maybe, screen time or too much computers or whatever is happening at that level. And so trying to manage that, we're supportive of Second Amendment rights. And in fact, our school teaches NRA gun safety, right? And then Eastern Wyoming College teaches gun making, and we support that industry. But at the same time, I think our biggest concern is self-harm. We do worry about, to a certain extent, active shooters. And with the active shooter situation, you want to have as many as sound kind of good guys who have concealed carry. That's a plus. Yeah, there's more security. But at the same time, we have a large percentage of people that, despite that, they kill themselves. And this doesn't reach the public record. My biggest concern as president is more of the self-harm and self-harm between students than an active shooter. We have all sorts of training. I think I would argue that my college in particular has that most active training that you can imagine for kind of an active shooter situation. We have armed guards. We believe in the weapons on campus, and other campuses have a different safety scenario. So, and studying the statute, it gets really, really, complicated. And I am no constitutional Second Amendment lawyer, and we try to huddle around this. And so, and talking to my colleagues, we like the idea of reciprocal carry. We love the Wyoming permit system because it requires you to at least get a check-in, go through the paperwork, and it's almost like a pause for students who are very at risk. We do studies of our students, and a lot of them have different levels of trauma, whether it be girlfriend, alcohol, immaturity. There's not a magic number where you all of a sudden become mature, right? But we like the idea that there's some sort of a permit. And so we like the reciprocal carry. We like the Wyoming But when constitutional, where it's just kind of free game, it becomes, and if we're looking at that student who's kind of like irrational and upset with the breakup of a girlfriend and had too much to drink and, oh, I'm going to kill myself or I'm going to kill my roommate. We like the idea that there's at least a pause, and we think that the percentage of people who kind of are responsible are those who go to the trouble to get some sort of permit in another state or in our state. And so in terms of this bill, this is a long-winded way to say that we'd like it to be able to say acceptance of reciprocal carry, but constitutional carry is just too open, given that bell curve of students who are go from very responsible to just out there as like, Lord help us, right? It's that mental health thing that I think that we all recognize is the problem. So we're trying to manage that mental health part of the bell curve and saying, if we can just get those folks to do some sort of a step. And that's why we love the Wyoming, the current statute with Wyoming permit. I think reciprocal carry would be likewise nice because at least they kind of checked in. And I think you're kind of, they're the people on the good side of the bell curve. It's kind of the permitted people, right? And so I think the position that we have on this is if we could make it just reciprocal carry. I've been told by a colleague, and I'm no expert on this bill, but they were saying on line 3, where it says, we're basically trying to add something to open it up to basically constitutional carry. Maybe there's something that you would say through line 3, small 3I instead of small 4, to somehow allow reciprocal carry instead of just constitutional carry, because we're trying to manage the disturbed, if you will. Right. And we recognize, I think nationally, that's the problem, right? It's not like the guns are the problems. It's guns in the hands of people. And we have lots of kind of unstable people and that we manage. So I hope that wasn't too confusing. And I appreciate your grace and your time on this matter, Mr. Chairman.
So Mr. Tyndall, what are the requirements of a permit? To obtain a permit, what do you have to go through to get a permit?
So what I understand on Wyoming permit, that you have to at least go through a little bit of training. That's not a lot, but it's a little bit enough to just have a reflective moment. And I understand what's nice about the system now is if you have a responsible kid, you can go and get that exception for age 18. So I think we have the system now. If someone says, I'm worried about my kid on your campus, I want them to have a concealed carry. I look them in the eyes and say, I know your kid, that's a good decision. I support that. And I think the current system allows that exception process for someone younger than 21 if they go to law enforcement and get that permission. So I like that. It's the people who I don't know if you have relatives in your family that some of them you would say, I think they lack a little bit of judgment and they're out there and maybe they have some addiction issues. But I think the current system is good, but if it could be expanded, how do we expand it to more responsible kind of good guys? I would say reciprocal carry.
Yeah, you really are all over the place. But a lot of your comments were based around mental health. And that's why I asked the question about a permit. And I am failing to see the nexus between having training and somebody with a mental health disorder not taking their own life or somebody else's life. I don't understand the nexus on how training would help in a mental health situation. The other comments that you just made about being responsible, having someone who knows how to use the firearm, has familiarity with the firearm, they very well may have received all that through training, but a lot of your comments focused on mental health, and help me understand the nexus between training and how that will somehow change whether a person with a mental health disorder uses a firearm improperly.
Thank you, Mr. Chairman. That's a totally fair question. I think what we're trying to get at is that incendiary moment where a young person suddenly gets angry or mad or depressed or whatever. And if there's a pause for that person who does not have a Wyoming permit, who's saying, I want to do something about it, it's a pause for them. If somebody already has that permit, no, it doesn't make any difference. So it's just that extra little niche of people to force them to pause, reflect, and not just react and do something rash in a moment.
Senator Colt, go ahead.
Let me tell you, thank you, Mr. Chairman. Well, thank you for coming. I think, what I've noticed is that the people in your world are slowly evolving over, I see it as more realistic point of what we're trying to deal with. And I appreciate that. One I want to point out is people that are, say, Title 25 people or whatever they may be that are having a mental issue or crisis, they don't care what your rules are. Okay. They don't care. They don't give a hoot. They don't think like you do. They don't think like I do. They're having big problems, right? So no matter what rules we think we make, it won't ever control those folks. We can't get here from there as it may be. I think we're getting to the point where I think people are seeing the reality of the situation, which is what I think I'm talking about is we're making rules for rational people, right? And you're saying, well, if we had these other rules, it's going to control the irrational people.
Yeah.
And I'm hearing that. So how do you square trying to make a rule for somebody who doesn't care about your rules and they'll come in and shoot people and are bad actors? And then you're trying to somehow, I guess, foresee what they might do, or you want to do something that they would follow. I guess I can't see how we get there from here besides having people have concealed carry, and which is a lot higher probability that they'll stop that said bad actor that we all want to control, right? But we're not going to control them through rational thought. Your views on that, I guess, I'm curious to hear what you think, sir. Thank you, Mr. Chairman.
Mr. Tyndall.
Thank you, Chairman. Thank you, Senator Cole. I agree with you. I think that they're rational. The consistently irrational characters are problematic, and therefore that's why you need the concealed carry of people who are not, right? It's this middle ground of think of it this way. If we were to propose this to be for 14 years old, you'd say, oh, you're not stable enough. Let's not even go there. We have within that bell curve, we have people who are not bad actors. They're not really sound. They're people that just blow up in the moment, given the fact they're just still young. They may be 19, but it's that group there, the good kid who's not crazy, who breaks up for the first time or second time they've ever been drunk and everything. And let's make it a little bit harder for that kid. So that's kind of the small, because I don't think this does, because the people who don't care about the law don't care about the law. I'm just worried about that good kid that, like, I have 3 good kids. I'm thinking, like, is there something I can do to make that just a little bit harder for that window of people?
And Mr. Tyndall, part of what I'm struggling with maybe is how you see the world, because an 18-year-old is an adult, but you keep saying kid. Help me understand does someone become an adult at a different age in your mind? Or I understand they're college students, but by and large, our society in the United States recognizes adulthood at 18.
Thank you, Mr. Chairman. I think you're correct. I do not see all 18-year-olds as adults. That's why I think when we have the Wyoming permit at 21 is a solid thing, because there are some people that are 18 are adults. There are some who are at 19 are not. And so we, as a nation, have to choose a date, and it's somewhat arbitrary, but you think that's a pretty good date for most things. You can vote, okay. You can die for your country. Then you're saying, okay, now this is a safety and a Second Amendment issue. And that's why I started out by talking about this bell curve. It's a sloppy thing. We're trying to support the Second Amendment and people's safety in a very squishy world where there's some sound adult 18-year-olds and there's some who really would be better to wait till 21. And currently it's 21 and we like that.
Senator Hicks, go ahead.
Mr. Chairman, could we redirect and get back on the bill?
Are we not on the colleges
Yeah.
and universities concealed carry bill?
Well, yeah, but I think we've delved way off what the bill actually does and into an area that's hypothetical instead of what the bill actually does.
Take us back, Senator Hicks. So that's enough to take us back. Okay.
All right, thank you.
We're back.
All right.
Any other questions? Anything else, Mr. Tyndall?
I just thank you for your time, and I recognize that this is a complicated space, and I appreciate the good work you all do in trying to figure this all out.
Thank you. Appreciate your testimony and your thoughts. Is there other public testimony on this bill? Good, because in fear of making Senator Hicks upset about getting off into the weeds, we're gonna close public comment. Come back to the bill. Committee, what is your pleasure?
Move the bill.
It's been moved by Senator Kolb and seconded by Senator Hicks. I am interested in an amendment, I think, to clarify this language in Romanet 4.
Mr. Chairman?
Yes, Senator Hicks, please.
The proposed amendment that you suggested would go in on page 2, line 7. After university, insert facility during and.
Okay. Senator Kolb.
Second.
All right, has been seconded by Senator Kolb. Any discussion on this? I think we kind of already had the discussion on it, but feels like that's gonna clear that up quite a bit. So there's no ambiguity. Yes, Pierre?
I think I understand the intent of the committee, but it should be for facility after athletic, university athletic facility.
No, I think it matches the language up above where we say college or university facility, public college or university facility during an athletic event. So it doesn't, yeah, I don't know if it's gonna be an athletic facility, the way I see what you're saying, Pierre, but I think we're good. Any other discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Okay. Any other amendments to this bill?
Question.
All right, Pierre, will you please do a roll call vote on House Bill 95?
Senate File 95. This is a roll call vote for Senate File 95.
House
Senator
Bill.
House Bill 95. Senator Craigo,
Excused.
Senator Crum,
Excused.
Senator Hicks,
Aye.
Senator Kolb,
Aye.
Chairman Olson.
Aye.
3 ayes, 2 excused.
All right. Last bill we have for our consideration is House Bill 96, carrying of concealed weapons, age requirement. Welcome back, Representative Haroldson.
Thank you, Mr. Chairman. So we're back here with House Bill 96, and this is kind of a secondary aspect to the conversation. And under current Wyoming statute, you can receive, as the good president of the college commented, you can receive a concealed carry permit, state issued permit at age 18. The problem that we're finding is it's quite limited and incredibly hard to get. And so case in point, an individual that's in the military, trained in the military, went to go get their concealed carry permit. Sorry, that's not a reason. And so it isn't a situation where we're just making sure that they're a respectful or mature 18-year-old. No, this is, you have to actually have a reason for security guard, something of that nature. So what we're doing in 96 is we're changing the conversation. We're eliminating that conversation of the opportunity for the sheriff to give that permit to an 18-year-old and saying, in the state of Wyoming and in the United States, a young man or woman can enlist in the Army. They can be tried as an adult. Why can't they go and receive a concealed carry permit as an adult? In the last couple of years, we've seen a push across the nation in the court systems where we're finding the restoration of an 18-year-old's rights is what I would say. We're having court cases where 18-year-olds are being told, yes, you can have the right to get a concealed carry permit. Yes, you can have the right to even purchase a handgun. So currently in the United States, there are 28 states that offer concealed carry permits to 18-year-olds. And of those 28, one of them only allows a permit to basically 18-year-olds in their state. The other 27 of them allow other states concealed carry permits to come in if there's reciprocity. And there's a whole list of that, and I'm not going to get into the depth of that. But this is something that we're seeing take place state by state across the union. And why is this important? I feel it's important in the fact that we have to take a stand as a state of saying, when's an adult an adult? And I think this is a way of making that reality. Another thing that is important to understand, if we were to go down this path of giving an 18-year-old, allowing an 18-year-old to get their concealed carry permit, all of a sudden we can send one of our young men and women from this state to, say, the state north of us, Montana, for work, and they have the ability to carry that firearm concealed with their permit across state lines and be protected in the state they go into. So with that description, I'm going to go into the bill. Page 1, section 1, we're seeing we're amending the 68104. So this is not the same 105 statute, it's the 104 statute. The 104 statute's permit. So we're doing the permitted section, and we're doing some amending as well as a repealer. So what does that mean? It's a really simple one. We strike 21, replace 18. We see that in there, and then we get some conforming amendments. And then on page 3, line 10, we see 68104J is repealed. What that is the conversation or the section of statute that talked about 18-year-olds getting a permit through the sheriff if they had a situation warranted. So that's the repeal. July 1st, 2026 gives the opportunity for 18-year-olds in the state of Wyoming to go get their concealed carry permit.
So Representative Haroldson, I want to just explore this from President Tyndall's point of view.
Absolutely.
So at age 18, yes, you can fight and die for your country. You can be tried as an adult. And now we're going to say, you should have more rights to a firearm. There are other things that we don't allow 18-year-olds to do. We don't allow them to purchase and use alcohol, purchase and use nicotine. I suppose a lot of the logic behind that is developmentally where the person's at. And at some point in time, we said, you're not mature enough or your brain's not developed enough to engage in the use of alcohol, as an example. I suppose there are people that would make that same argument about maturity with the use of a firearm. Help me explain why this falls out of the 21 category and really is solid in 18.
Thank you, Chairman Olson, for that question. And I think two things I would say. First of all, our courts have said this is a constitutional right given to an 18-year-old when they become an adult. So we've got that nexus out there that needs to be understood and discussed. I'll be honest with you, and I'm a pastor, so I say this very, very carefully. I struggle with the fact that we don't allow 18-year-olds to be adults. I struggle with the fact, and I'm not saying we should put a bottle in an 18-year-old's hands. I'm not saying that. But I do think there's a conversation that needs to be had in the fact of you're either an adult or you're not an adult. And I really struggle with the fact that a decision made when I'm 18 years old and one day could put me in jail for the rest of my life, or even younger than that, because we could be tried as an adult younger than that. And at the same time, we hold back other rights. And so I do struggle with that conversation and concept. Will you see me bringing a lowering of the drinking age bill to the state of Wyoming? Absolutely not. Because I've also seen the damage and the pain that has caused in families. But I think that there is a concept of 18 is an adult in the court's view. They've ruled as much on a federal level and said the same. And so I think that giving them firearm rights is only right constitutionally as well as intellectually. Now, as we talk about maturity, there's a lot of different levels of maturity. One of the things we have to be very careful of is it the role of the government to dictate the maturity of people, to say what's mature enough? I think we could all agree we've met people well over 18 years old that are not mature enough to do many things. I think probably every person in this room at some point in time could, if they were put underneath the microscope of life, could even be called maybe not mature enough ourselves, because that's humanity. But maturity doesn't negate rights. And I think that's important to understand as we look at the context of firearm rights and our Second Amendment rights.
Other questions for Representative Haroldson? Senator Cole.
Yeah, thank you, Mr. Chairman. Oh, Representative, Yeah, I can say I was drinking when I was 18 because that was the law. Can't say it's ruined me or anything, but I don't think that's the end of the world either, but that's irrelevant to this. The question would be is, thank you there. The question is that under what circumstances, if any, can the sheriff deny the issuance of a concealed carry permit, say if this bill was to go forward?
Representative Haroldson.
Thank you, Chairman Olson and Senator Kolb. So you still have to go underneath a full background check, 10-finger background check. And so if an individual fails their background check, then at that point, there is going to be the conversation you then don't get your concealed carry permit because you failed it. So this isn't a judgment by the sheriff at this point. This is clearing a background check, getting permit. That's the process, just like a 21-year-old would be currently in the state of Wyoming.
Senator Kolb.
Yeah, thank you, Mr. Chairman. So it's clearly just a research your background. And then if you clear the background checks, that's that. So the sheriff, the only duty is, I guess, is to scrub your background, but wouldn't DCI do the same thing?
Correct.
Representative Haroldson.
Thank you, Chairman Olson and Representative Kolb. I think if I'm hearing your question correctly, under current statute, what is that sheriff's role and goal in deciding is someone capable of getting that? The same background check is done through DCI for an 18-year-old that is done for a 21-year-old. The sheriff's position is, what is the reason for you requesting? So maybe the reason for me requesting, if I'm an 18-year-old and I'm working a security position for a security company and I need to be able to conceal a gun in that role. At that point, then I have a reason for them to process that, and that reason would then be used for that process. But it's the same background check for an 18-year-old or a 21-year-old.
Senator Hicks.
Yeah, Mr. Chairman, Representative, do you have a list of those companies that hire 18-year-olds for security officers? Because if you do, I want to make sure that I never hire them. But anyway, just a rhetorical question, Mr. Chairman.
I'm not going to comment.
Yeah, I'm going to rule that comment out of order. All right. Thank you, Representative Haroldson.
Thank you.
Any state agencies wishing to testify on this bill? Welcome.
Welcome, Mr. Chairman. Oh, thank you, Mr. Chairman. Members of the committee, my name is Corin Schmidt. I'm the Director of the Wyoming Department of Family Services. And just a little bit of information for your edification. And it was hit on in regard to the background check. If there is a youth that has been determined to be a delinquent under juvenile court, and they had committed a felony, that information would not show up in a background check because it's subject to confidentiality. So the change in this particular statute then, by relying solely on the background check, will then not include juveniles who have been declared delinquent under juvenile court jurisdiction.
Okay, Director Schmidt, but that's true even under our existing law. When we run the check at 21, it's still only going to show 18 to 21. It's not going to show a juvenile delinquency, correct?
Mr. Chairman, and I am not an expert in these statutes, so certainly deferring to Representative Haroldson and the rest of you. My understanding is currently what the law allows for is for a sheriff's department to inquire or to have to inquire or has access to more information than just a background check for 18 to 21. So if law enforcement has knowledge of whatever the behavior was with the juvenile, then they could disregard that. So that's my recollection of the statute. This is an issue that we had discussed with Representative Haroldson prior. And I think that was really where we nailed in on the difference between
And I'm
now
not an expert in this either, so I'm trusting you. But I guess I always thought that a sheriff's office, a prosecutor's office, the Division of Criminal Investigation. I just thought that they always had access to juvenile records. I thought it was more of the public that could not access a juvenile's record. So you're saying that the Division of Criminal Investigation, the sheriff's office, would not have access to any juvenile records during the background check?
Mr. Chairman, that's my understanding.
But they currently don't have that access.
Mr. Chairman, no, they currently don't have that access, but they do have, they can pull in the knowledge that they may have about that juvenile otherwise. So for example, in a community, if a sheriff's officer was part of the arresting incident where a juvenile was arrested, filed in juvenile court, determined delinquent, yes, but when deleting the laundry list that's currently in statute, it takes away their ability to draw in that information and making a determination.
Okay.
Right.
Representative Haroldson, can you help us out here?
Thank you, Mr. Chairman. And so I'm going to just read the subsection J that's being repealed, because that gives that nexus of what the sheriff can do. And it just says, the sheriff of the applicant's county of residence may, at his discretion, submit a written report to the division recommending the issuance of a concealed carry permit to an application between the age of 18 and 21 years of age who meets the requirements specified in this section. The written recommendation shall specifically state that the sheriff has personal knowledge of the applicant's situation or circumstance which warrants the issuance of a concealed carry permit. The division may issue a permit to carry a concealed firearm to those individuals between 18 and 21 years of age under circumstance that is that a reasonable, prudent person would believe warrant the issuance of a permit to carry a concealed weapon. The decision to issue a concealed carry permit shall be based on the satisfactory completion of the requirements of this section and any voluntary written report offered by the sheriff of the county of the applicant's residence, which shall clearly state the reason the applicant should be issued a permit. The applicant may submit a written report containing relevant facts for consideration by the division.
Okay, so I got that, but there may be additional information in a person's background between 18 and 21. I understand that but what if they are under 18 and juvenile? Under the current law, there's still no access to that information. So that's not changing with this bill.
That is correct, Mr. Chairman. So current, if there was someone that committed a felony as a juvenile, not tried as an adult, but tried in a juvenile court, that is not applicable or available current or with new.
So we could argue, that's a problem that we currently we have, and
sure,
we can choose to address it if we wanted to access that information, but it's no different than what we already struggle with.
Absolutely.
Okay.
Yep.
Okay, that makes me feel good.
Thank you.
All right. Thank you, Representative Haroldson. Anything else, Director Schmidt?
No, sir. Thank you.
All right, thank you. Public testimony? Start with Councilman Moody.
Thank you, Mr. Chairman. Through you, I support it. I think it's a good bill. Thank you.
Short and sweet. Any questions for the councilman? All right, thank you. And then would you like to go next, ma'am, or go ahead?
Any order is fine.
All right, go ahead.
Chair Olson and the Judiciary Committee members, I thank you for the opportunity to testify. I am Beth Howard of Cheyenne, and I am here to testify on my own behalf against House Bill 96. If House Bill 96 proposed allowing only active duty service members under the age of 21 to obtain a concealed carry permit, as they do in other states, I would not oppose it. My own son enlisted in the Marines at age 17, but this bill does not do that. Though some states have passed bills like this bill, many have not, and there is a reason. It is a bad idea. The gentleman from the community college stated it clearly. There is no magic age where you suddenly become mature. But having raised 3 sons, I can pretty much assure you it is not 18. Based on homicides in Wyoming over the past few years, it is obvious that many teens in Wyoming are already armed and making up the poor decision to kill each other with firearms. Just a few months ago on November 12th, 2025, 18-year-old Vincent Gardia was shot and killed in my neighborhood in North Cheyenne. Gardia and 2 friends, 16 and 17 years old, allegedly came to purchase, but then attempted to steal a firearm from 17-year-old Jareem Turner. Turner shot and killed Gardia. Now 1 teen is dead and 3 are facing charges as adults. All these lives have been destroyed. Among the 4 teens in this incident, there were 3 firearms: a Smith & Wesson 9mm handgun, a Glock 30, and a Charter Arms .38 caliber revolver. Teens are already armed and making poor decisions with firearms. Let's not make the problem worse. The issue of illegally armed teens must be addressed prior to any consideration of lowering the concealed carry age. Please protect our children and our communities by voting no on House Bill 96. I stand for questions.
Any questions from Ms. Howard? All right, thank you. Mr. Gosh.
Thank you, Mr. Chair, members of the Senate Judiciary Committee, Brian Gosh, again, National Rifle Association. House Bill 96, of course, does deal with people who are not prohibited persons, people who haven't committed felonies, people who haven't committed heinous crimes, juveniles who haven't been tried as adults eligible for a carry permit. Currently, 28 states do allow 18 to 20-year-olds to get a carry permit. Wyoming would be the 29th and would be one of the last red states to allow it. Some of the references made previously to types of restrictions, those are going to be found in what we call blue states. One of the things Representative Harrelson talked about was federal case law in support of 18 to 20-year-old permit carry. So somewhat recently, this was a 2024 case in the 8th Circuit. I know that's not our circuit, but in the 8th Circuit, which is just going to be to the east of us, a case called Worth versus Jacobson. That holding was that state laws that impose a minimum permit age of 21 were invalidated. One of the things the court said there was that the normal and ordinary meaning of the people in the Second Amendment includes all Americans who are part of the national community. In another case, in 2023 in Tennessee, on the same issue, there was a settlement reached between the parties, and now the Attorney General has to start receiving applications for age 18, 19, and 20 permit carry. I imagine you're going to see different decisions coming out of different circuits that have, different types of states and federal judges appointed by different presidents, and ultimately you might have a case go before the United States Supreme Court. But at least in those jurisdictions, they have said you have to allow 18 to 20-year-olds to carry. If a 18, 19, 20-year-old in Wyoming does get a carry permit, they do also have to have training. So one of the questions was asked was what could prohibit them, because we are a shall issue state. And so if they're not a prohibited person under the federal or state law, and they have had that modicum of training required by statute, then they shall be issued a permit. And then they can go and travel into 36 other states and legally carry concealed. There's 3 states they won't be able to, because those 3 states won't give them reciprocity. And then there's 10 other states that will never grant reciprocity to anybody from out of state. You can imagine those are states like New Jersey, New York, Massachusetts, California, states like that. The carry permit here doesn't give you as much reciprocity as the one in South Dakota or North Dakota has. If you get a permit there in those states, you're legally to carry concealed in up to 40 states. But this issue before us, and this bill doesn't deal with that. That might be something we could tackle down the road. But for now, we're looking at giving the right that at least some federal courts have said you have to give, and that many other states have granted to 18 to 20-year-olds. I guess with that, I would stand by for questions.
Chairman?
Yes, Senator Hicks.
Mr. Chairman, Mr. Gosh, does Wyoming currently have constitutional carry for 18-year-olds?
Mr. Gosh.
Constitutional carry for 18 to 20-year-olds. I think you got me stumped currently. I don't believe so. I don't believe we do.
I think it's 20.
And I think this would extend that to 18 to 20-year-olds also.
So, Mr. Chairman, the question comes up for constitutional carry. There is no requirements for any training, any permitting, any background checks or anything. So even though we're lowering the bar here, there comes with a whole other set of requirements to meet that bar. Is that correct?
Yes, Mr. Chair and Senator, that would be correct. And that's what gets you your reciprocity. Now, there's a lot of other states that have constitutional carry, but if you want your maximum legal states to be able to carry concealed in, you'll have to get this Wyoming permit.
Thank you.
Yeah, just for clarification purposes, it looks like Wyoming in 2021, when we enacted law that specifically said constitutional carry applied to a resident 21 and older. So, Senator Kolb.
Yeah, thank you, Mr. Chairman. Mr. Gosh, I have just a question about those 20 other states and when they changed the law and lowered
28.
Okay, yeah, 28. I'll stand corrected. Has there been any incidents that you're aware of as it applies to those states that went to 18-year-old status for concealed carry?
Mr. Chair.
Mr. Gosh.
Senator, I am not aware of any incidences now, because the question I presume pertains to just deal with the reason they have the permit or got the permit. They would have had to undergo a background check. In some states, they would have had an extra step of being fingerprinted because that's what gets you some of the additional reciprocity in some of the other states. And by virtue alone of their age, no, but can anyone of any age turn evil and cause problems? Of course. But by simple virtue of their age and getting a carry permit, that has not been a problem.
So, Mr. Gosh, I'm going to ask you a question you may not know the answer to. If you do, great. But of those 28 states that allow concealed carry for 18-year-olds, do you know if any of those states allow for a background check into a juvenile's history?
Mr. Chair, I'm not aware of that because, of course, we know as lawyers the whole purpose of the juvenile system is to protect minors from mistakes they made in their youth, so that it's not held against them as adults. And of course, the second step is there's certain crimes that are so heinous they will be tried as an adult, even though they are a minor, and they'll suffer the consequences of adult prosecution. But in all other cases, that intent to pierce the juvenile system veil, if you will, I'm not aware of that existing in other states.
So we would probably be just the same as the other. I mean, that's kind of what my gut's telling me too, is that I doubt any of the states allow access to those juvenile records. So we would be just the same as half the country.
Yeah.
Okay. Any other questions for Mr. Gosh? All right, Mr. Jones.
Thank you, Chairman Olson. Again, Mark Jones with Gun Owners of America. The question was raised earlier, why this is different from something like drinking or some other things that our society has decided to restrict. And I would argue the first major difference is the right to keep and bear arms is a constitutionally protected right, unlike some of these other things that different states choose to restrict for certain classes of people. I would also argue that the current system is ripe for a judicial challenge. I would imagine there are some sheriffs. In fact, I saw one sheriff went on record when this bill was announced, and he said he pretty much issues these carte blanche to anybody that wants them. But I can and I won't do it, but I could probably name a couple sheriffs in this state that would never issue one of these based on their view of the Second Amendment and testimony we've heard in this chamber in the last 3 weeks. I would think that means that we're seeing constitutional rights applied in an unequal manner for 18 to 20-year-olds right here in the state of Wyoming right now. And I think there have been court cases in some other states, including Tennessee, where these types of things have been challenged. I also kind of wanted to address this concept of, oh no, we're going to have young people with guns shooting each other. You know, Chicago has the strongest gun control laws in America, and all this stuff is illegal. And I know many years during our wars in Iraq and Afghanistan, Chicago was more dangerous than those Middle Eastern countries. So gun control doesn't stop people from doing things they shouldn't do. And regarding this issue of reciprocity, my colleague, Mr. Gosh, mentioned this. This is probably one of the most important components of this bill. We have 18, 19, and 20-year-olds that go outside the state of Wyoming to work or to school. Let's say we have a 19-year-old young lady that goes to nursing school in Colorado from any town in Wyoming. The only way she can protect herself and stay legal under Colorado law is to have a concealed carry permit from the state of Wyoming and be granted reciprocity. You can make the same case for a young man who goes to another state to work. So we can help Wyoming young people who leave the state by establishing this permit for this 18 to 20-year-olds and allow them to exercise their constitutional rights. I could probably go on and on, but in the interest of time, I will stand for any questions. And thank you, Mr. Chairman and committee, for hearing this bill and for your time.
Questions for Mr. Jones? All right, thank you. Any other public testimony?
Chair Olson, could I make one more
Sure. Go
comment
ahead, Ms.
in
Howard.
regard to
Howard, go ahead.
something that was shared? Some of the states we have reciprocity with have an age of 21, and Colorado would be one of them.
Mm.
So I think it's worth considering how it will affect our reciprocity with some of our neighboring states.
Mhm.
Thank you.
Thank you. President Tyndall.
Thank you,
Welcome
Mr.
back.
Chairman. I think you heard a lot of my thoughts before, so I'll keep this short. I was given from our Wyoming Association of Community College Trustees 4 paragraphs to read, but I'll make it 3 because I really do think you have been indulgent to let me to spend quite a bit of time up here. But I think they would appreciate because if they went to the trouble of writing this. So if I may, most legislators across the spectrum of views on firearms would not support allowing an 18-year-old high school senior to carry a concealed firearm in a school hallway. That is not because anyone doubts their constitutional rights. It is because we recognize that high school students are still developing judgment, still learning to manage stress, and still gaining the maturity that comes with early adulthood. That is why the state has long drawn a clear line at age 21 for concealed carry. House Bill 96 would erase that line. It would allow the same 18-year-old who could not carry in their high school on a Friday to walk across the street on Monday after graduation and carry concealed in of anxiety and depression, greater exposure to alcohol and substance abuse, intense academic pressures, and far less daily supervision. Community college
Move the bill.
It's been moved by Senator Kolb and seconded by Senator Hicks. Any amendments to this bill? Or any discussion on it? Senator Kolb, go ahead.
Yeah, thank you, Mr. Chair. Just to make it real clear that you can't, you have to be over 21 to conceal carry on school grounds on K through 12. I think that was kind of, sounds a little confusing maybe to the people maybe listening. To be very clear, that hasn't changed. There's other reasons why that can't be any school.
And I think even if you are a student at the school and you're over 18, you still can't carry. So just to be very clear on that. Okay. So this law does not change anything for our K through 12 schools. Okay. All right. Here, will you please do a roll call vote on House Bill 96?
This is a roll call vote on House Bill 96. Senator Crago,
Excused.
Senator Crum,
Excused.
Senator Hicks,
Aye.
Senator Kolb,
Aye.
Chairman Olson.
Aye.
3 ayes, 2 excused.
All right. Thank you. We are adjourned. We'll see you Monday.
Can I see that?